constitutional right to privacy in our personal lives. In Florida, this right is more protected than in many other states. But how does that change when you are involved in an accident? In today's Injuries Are Personal with Carl Reynolds Law, attorney Camilla Brannon is here to discuss how private is your private information, especially when you make a personal injury claim. Interesting topic. Welcome.
Good morning.
Great to have you with us.
Good to be back.
Is this something that keeps people from making claims, do you feel?
People certainly are concerned about it. The
Yes.
issue has come up recently with the recent headlines with folks attending a concert. There were some certain repercussions for them personally.
Right.
And in response to what happened, one of the parties mentioned, well, I had an expectation of privacy that may have been violated. Legally, I don't know that that is a sound argument, but we certainly have very strong expectations of privacy. We have right to privacy in the United States and in Florida especially. We have very strong privacy rights. And the law protects those privacy rights in the context of, for example, criminal law. You know, the government can't come into your home and search your home without good reason. In the context of what we do, which is a Carl Reynolds Law, which is representing folks who have been injured through other parties, for example, insurance companies, trucking companies, defendants do have access, limited access to your personal information. There's an expectation of privacy in regard to medical records, in regard to employment records, tax records. Nobody can go and call your doctor and, hey, can you send me the last 7 years of Miss medical records? It is up to the attorney and, quite frankly, up to us to make an objection with the court if the insurance companies or the defense lawyers or whoever is responsible for causing the injury oversteps those boundaries.
So when I'm involved in an accident and I am seeking help and damages, I know that I'm going to release things to my attorney. What do I know that gets released to the other parties?
Good question. Many times, sometimes we get folks who try to do it themselves, handle their own claim. And they come to us and they say, oh, I signed this authorization. What they don't realize is that they have opened up all kinds of information, their life, to somebody who may not be entitled to that unbridled access. What we do is we serve as the gatekeeper insofar as what is relevant and what's not, and it's up to the court to balance that fine line between the need and relevance, and really what is discoverable, what the defense is entitled to is relevant information and something that's at issue in the case.
And as it becomes part of the case, then it's released to the court. Let's say it goes to trial. At that point, is it public record?
It can become public record, absolutely. You are, as a person who's claiming injury, you are putting that at issue, your medical history. There are certainly boundaries. There's boundaries as to how far back the defense can go. How, for example, some folks claim that they've lost wages. If that is not a claim in your case, then your tax records, your employment records are to some extent privileged and confidential. So we are very careful in ensuring that those boundaries are not crossed, and you know, that the need for disclosure is balanced against the need for privacy.
And this isn't something we usually talk about when you're deciding whether or not to work with an attorney. You know, it's one thing to be like, no, it's okay, I got this, but then if the other side, we all know they're big, powerful insurance companies with, you know, big attorneys working behind them. They know how to drag names through the mud and get all of this, you know, squelched.
Absolutely, and there are concerns. For example, putting your medical, for example, let's say that your knee was injured or your shoulder was injured, does not mean that your entire medical history comes at issue. You know, if you have had mental counseling, which many people do,
sure,
unless you make that claim, it's not something that should ever become a part of your case.
So don't sign an authorization paper. I know that's without speaking to an attorney.
That would be my advice.
Yep, and that's, I know, one Carl always gives as well, especially about don't take settlement payments without speaking to an attorney, because unfortunately the big companies sometimes know more than we do. So, all right, for more information about any of your legal questions, you can find Carl and his team by going to injuriesarepersonal.com.